H-1B petition approved for employer A. They're working for employer A in valid H-1B status, and they have a separate H-1B petition for employer B. So that's a key factor here for almost all of these visa classifications that we're going to talk about. There has to be a separate petition for each employer. So employer A and employer B both have to have filed an H-1B petition. In this example, we're talking about the H-1B classification. It is not accurate. It's not true that a person can hold H-1B status. Let's say employer A files an H-1B petition for John Doe. It's not true that John Doe can then go use that H-1B status and work for employer B, either at the same time or down the road. Each separate employee or employer rather has to file its own H-1B petition, and they have to adhere to the terms and conditions that are stated on the labor condition application. So that means the number of hours that they're going to work, the wage that's going to be paid, worksite conditions, things like that. So for the H-1B, yes, you absolutely can have concurrent employment, but like I said, each employer has to have their own separate petition. With concurrent employment, and again, this is true for any number of visa classifications. Of course, this is not legal advice. This is for general informational purposes only. So make sure you talk with a qualified immigration attorney. But generally speaking, for concurrent employment, either of the opportunities can be part-time or full-time. And we'll talk again in a minute about an example about that part-time versus full-time. But it can be a combination thereof. One can be part-time, one can be full-time. It's really about telling the story, the true story, the accurate story to USCIS, and convincing them that you are able to do whatever it is that you say that you're going to do. So I've had situations before where clients have 2 40-hour-a-week jobs. That makes for an 80-hour-a-week work week, which unfortunately is not overly uncommon. It's not something I ascribe to, but it's possible to do. On the other hand, if you say that you have a position at employer A and you're going to be working there 1 hour a month, USCIS is probably going to question whether that is a true job opportunity or not. The O1 visa classification is another visa classification that allows for concurrent employment in general. Like I said, each employer has to have their own separate O1 petition that is filed and approved with USCIS. It is possible that O1 is a little bit different in that there can be an agent in O1. Visa holder can have an agent instead of a more traditional employer, and there may be multiple employers, for lack of a better word, or work sites, multiple opportunities listed within that O1 petition. So it's a little bit different for the O1. TN visa holders absolutely can have concurrent employment, and that's something that is not talked about, I think, as much as you hear a lot about H-1B concurrent employment. You don't hear about it as much for the TN, the H-1B1, the E3 classifications. We have done concurrent employment for visa holders for all of those classifications, TN, H-1B1, E3. Again, just like the H-1B, each employer, or the O, each employer has to have their own petition. For the TN, the process can be a little bit different because you can apply for the TN at the border, at the port of entry, but it's critically important that the not even the visa officer, but if you're entering from Canada, for example, the officer at the port of entry knows that you're working for both employers. So you don't want to enter and say you're going to work for employer A and then be like, oh, I have TN status for X position, so I can just go work for employer B at the same time because I have TN status. It's all good. No, you need to go through a formal application process and make sure that the government knows what you're doing. So make sure you have a clear conversation about that. We've had that come up before in our practice. But like I said, in general, as long as each employer has their own petition, if it's a petition-based filing, then it is permitted. In addition, if it's a type of filing that requires an LCA, of course, you have to have a proper LCA, labor condition application, for that job as well. And each individual employer has to adhere, like I said a minute ago, to the terms that are outlined in that labor condition application. So the labor condition application is a form that is required. We file it with Department of Labor, and it's required for H-1Bs, H-1B1s, and E3s. And we attest there, or the employer rather, attests how many hours that information is actually in a petition, but they attest there the salary that they're going to pay the person, and then the employer has to adhere to that. They have to actually pay that salary, whether it's expressed in hourly amounts or annual salary amounts, they have to adhere to that, whether it's just one petition that the foreign national worker holds or a concurrent petition. For F1, for OPT and CPT, it depends on the work authorization, whether you can have concurrent employment. It's usually more common, for example, in the OPT realm or the STEM OPT extension. It's a possibility. Regardless, you have to make sure that your I-20 is endorsed, is set up to accommodate these employers. So make sure that you have a clear conversation with the DSO if you're thinking of doing this, and make sure that all of the paperwork is in order, that the I-20 is set up for that. And also any experience that you have, whether it's CPT, OPT, STEM OPT, that has to be directly related to the field of study. You can't just say, oh, I have OPT, so I'm going to go, work at this retail store for a few hours a week because I have a valid EAD. No, it has to be on your I-20. You have to go through a formal process, and it has to be related to your field of study. In general, there are other visa classifications that are usually not as flexible in terms of concurrent employment. For example, the E2 visa classification is for treaty investors. So a person who's investing in a business in the United States, purchasing a business or creating a business in the United States, either way. Or the E2 can also be used for specific employees of E2 registered companies. In any event, typically just the logistics of the E2 make it such that it's really not possible. It's not feasible. Generally speaking, there could be exceptions for sure, but generally speaking, it's not possible to have a concurrent employment on the E2. The other type is the L1 visa classification for multinational transferees. So meaning you've worked for an overseas entity and you're being transferred to the US. That would be an unusual situation. There may be a situation where you're working for perhaps two different entities that are both related to the overseas entity. Again, that's a more complex case, and you need to talk to your immigration attorney to make sure that that is doable in your case and that it is documented and everything is on the up and up. But generally, those classifications are ones where you would not be working for two different, especially unrelated entities. So key requirements for concurrent employment, whether you are the employer or the employee, compliance is always important, but especially in this day and age. Each employer, like I said, has to have their own petition, or there has to be some paperwork in place, depending on the type of visa classification, to indicate that you as the employer are sponsoring that person for that particular type of visa classification. In addition, each employer has to adhere to the wage obligations, like I said, and making sure that you're adhering to what's listed in the petition or the visa application in terms of the number of hours, if it's a part-time position or full-time, and offering the job description that's actually in the filing. I know that seems like it shouldn't need to be explained, but we do need to make sure that if you are working in any position, that it is actually the position that is listed in the petition or the visa application. In general, for this type of filing, you have to file the concurrent petition before you begin working. So for example, if we have an employee who holds H-1B status with employer A, and then our client, employer B, wants to hire them on a concurrent basis, meaning they're going to work for employer B, for our client, at the same time as employer A, we have to have that H-1B petition filed, the concurrent petition filed with USCIS before they can begin working. And the rules are different depending on the different visa classifications. Sometimes there's portability, like in the H-1B context. Other times there's not, and the petition has to be approved before they start working for the second employer. Keep in mind that working for any unauthorized work, if you're working for an employer for which you are not authorized to work, is considered a violation of status. So for example, if you hold, let's say that you're on STEM OPT, for example, you're working for the employer, you're being paid the required hours, you're adhering to all of the compliance requirements there, and you're also driving for Uber. Even if that could be considered self-employment, if you get like a 1099 from Uber, for example, that's a violation of status because you are not authorized to do that work. And honestly, it can be as small as, I hate it when I hear people that are, saying that they're babysitting in the United States and they're being paid in cash under the table. I know that realistically, a person needs to earn money, but it can be a serious problem for your immigration status down the road. So just know that in general, you are work authorized only for the opportunity or for the, the petition that you have approved or filed with USCIS or the visa that you have. And if you violate that, if you go off and do work that is not listed, that's not authorized, that can be a huge problem for you down the road. So we talked, when we first started this, we talked a few minutes ago about when we started talking about when this might come up. I want to give you another example, and I've talked about this before in other videos, of when this might come up. So we said before, it's very common in the vet industry for a vet to want to pick up shifts at another hospital, perhaps overnight shifts or weekend shifts. Totally fine, but they have to have a valid petition, depending on what their visa classification is. They have to have that valid petition with the second employer where they're going to pick up those shifts. Likewise, it's common, like I said, for H-1B workers to have concurrent employers. And one thing that I want to point out, and like I said, I have a separate video on this in Sumner School Business Immigration Basics, which is a series that we have on our YouTube channel. It is possible, concurrent employment is possible on an H-1B just in general, but also there's this very, it's not easy to do, but it can be really cool when it works out. You can work, an H-1B employee can work for a CAP exempt employer. For example, a university, a nonprofit that has the required affiliation with an institution of higher education, whatever it is. But you can work for a CAP exempt employer and concurrently work for a CAP subject employer without having to be counted against the H-1B CAP. Now, if you stop working for the H-1B exempt employer, then you're no longer able to work for the CAP subject employer unless you go through the whole H-1B lottery and you're selected and all that. But that can be a really great way to be able to work in the private sector, even though you weren't selected in the H-1B lottery. So again, we have a more detailed video on that in Sumner School Immigration Basics on YouTube. So check that out if you're interested. I hope that you have found this information helpful. I would love to hear from you if you have questions about concurrent employment for your employees or for you as an individual. Feel free to put questions in the comments here and we'll answer them if we're able to. We can't give legal advice outside of a consultation or outside of a legal relationship, an attorney-client relationship. So if you need more detailed advice, then definitely set a time for a consultation and we'll have information on how to do that at the end of this video in just a minute. I hope that you found this information helpful. If so, I hope that you will share this video with a family member or a friend and make sure that you are subscribed to our channel wherever you are watching this, whether it's on LinkedIn, Facebook, or YouTube. Otherwise, my name is Emily Sumner with Sumner Immigration Law. We assist clients around the United States and around the world with family-based and employment-based immigration matters. And we look forward to seeing you next Tuesday for our live at lunch at Tuesday at noon Eastern. Until then.